expression excludes all other classes. You want to argue with something? Subject to correction, probably your Lordship's attention to this clause expression only was not brought to you. Yes. My lords. Sorry. Then may I request your Lordship's attention? Supreme Court, the lawyers are not present at all the time, so they don't know what is argued by the others. Too much work. Anyways, may I request your Lordship to another expression, that the explanation that we have given in paragraph number 28. Because otherwise, one was the yes. Turning to the fourth question, it is necessary to examine whether a person who has partly served as a civil judge and partly practiced as an advocate for a combined period of 7 years can claim eligibility under Article 233(2). The plain text of Article 233(2) provides the answer. It uses the expression, a person not already in service of the union or the state shall only be eligible. I was pausing here for a moment to meander. The consequences of inclusion of those who are already in judicial service from the bar quota will have its own cascading effects. Because a person who is already in bar is not permitted to compete or appear from the judicial services category. How can that be? Not yes. You are arguing something which is totally unknown to the service jurisprudence. No, certainly no. Therefore, in our humble submissions, what is this? Inclusion. May I just formulate? Permitting, suppose tomorrow the officers of the judicial service are permitted to compete from the bar quota. It is not reverse applicable. There is no reverse osmosis applicable here. Then, in that case, it would also amount to the reverse. Are you arguing with seriousness? Sorry, but then this is our stand specifically mentioned in paragraph number 22, 23 onwards. Thank you. Manoj. So, arrest my case, Manoj. Yes,
please. I'm appearing in 501.11 minutes. I'm appearing for the High Court of Telangana. My written submissions are at page 115 of volume 2 minutes. Much has been argued, my lords. I'll really bring to your lordship's attention 3 points, my lords, which have not been addressed before your lordships. The first point, my lords, is with respect to the principle of constitutional silence. It's a given fact, my lords, that in any written constitution, there are certain silences which are on purpose left there, certain deliberate omissions. This is, my lords, this submission is with respect to question number 4 before your lordships today, where the explanation is specifically given in 124 and 217, and under 233, the constitution framers left that silence, my lords. That is not to be filled up before your lordship. Your lordships may kindly have, my lords, one judgment, Manoj Nerula, my lords, which is, my lords, at page volume 5.3, my lords, page 778.
What if?
5.3, my lords. The judgment starts, my lords, at page 778. The relevant portion that I would like to point out to your lordships is at page 829, my lords. Paragraph 54 to 56, my lords, of this judgment. It's a constitution bench judgment, my lords. This judgment, my lords, was in respect of disqualifications regarding to MPs and MLAs, while looking into a constitutional silence with respect to another disqualification which was sought to be added. This Honorable Court, by way of a constitution bench, held that that silence would not be filled up, my lords.
It's page 7.
Page 829, my lords. The judgment starts, my lords, at page 778. Relevant portion, my lords, at page 829. May I read, my lords? Paragraph 54. The next principle, lordships have it.
Yes.
The next principle that can be thought of is constitutional silence or silence of the constitution or constitutional abeyance. The said principle is a progressive one and is applied as a recognized advanced institutional practice. It has been recognized by the court to fill up gaps in respect of certain areas in the interest of justice and larger public interest. Liberalization of the concept of locus standi for the purpose of development of public interest litigation to establish rights of the haves-nots and to prevent damages and protect the environment is one such feature. Then, my Lordship may have para 55 minutes. In this context, it is profitable to refer to the authority in Bhanumati versus State of Uttar Pradesh, wherein this court was dealing with the constitutional validity of the UP Panchayat Laws Amendment Act 2007. One of the grounds for challenge was that there was no concept of no confidence motion in the detailed constitutional provision under Part 9 of the Constitution. Therefore, incorporation of the said provision in the statute militates against the principles of Panchayat Raj. In that, Mallards, in the judgment of Bhanumati, which has now been recognized by the Constitution bench, Mallards, the next page, Mallards, at page 830. Bhanumati is quoted, Mallards, para 49 and 50. If I may read, Mallards. Apart from the aforesaid reasons, the arguments by the appellants cannot be accepted in view of a well-known constitutional doctrine, namely the constitutional doctrine of silence. Michael Foley, in his treatise on the silence of constitutions, has argued that a constitution abeyances are valuable, therefore, not in spite of their obscurity, but because of it. They are significant for the attitudes and approaches to the constitution that they evoke, rather than the content or substance of their strictures. The learned author elaborated this concept further by saying, despite the absence of any documentary or material form, these abeyances are real and are an integral part of any constitution. What remains unwritten and indeterminate can be just as much responsible for the operational character and restraining quality of a constitutional as its more tangible and codified components. Going further, Mallards, at para 56, which is the most important part of this judgment, Mallards, the question that is to be posed here is whether taking recourse to this doctrine for the purpose of advancing constitutional culture, can a court read a disqualification to already expressed disqualifications provided under the Constitution and the 51 Act? The answer has to be in the inevitable negative, for there are express provisions stating disqualifications, and second, it would tantamount to crossing the boundaries of judicial review. In the present case before your Lordships, Mallards, specifically, the explanations under 124 and 217 have not been consciously and deliberately not been included within 233 minutes. In fact, Mallards, the learned senior for the petitioners, Mallards, has argued that the explanation under 217 does not refer to advocacy experience before holding a judicial office, but only refers to the one after, so it would not. But that, in fact, would inure to my benefit, Mallards. Even under 217, any advocacy practice before holding of judicial office is not being counted. So any clubbing to that respect, my lord, in my respectful submission, ought not to be taken. The second point, my lords, that I would like to make is with respect to, my lords, the necessity for the direct recruitment and the quota. As lordships have already seen, right from 1920, there has been a quota which has been 1/4 for bar members. That, my lords, in fact, has also been specifically noted by the Law Commission report, my lords, in, if your lordship may have, volume 4R, my lords. The Law Commission report specifically says that direct recruitment from the bar is necessary to infuse fresh and young blood, my lords. So this one point, my lords. One alternative submission, my lords, which I would like to place before your lordships, is that even, I'll take it against myself, my lords, that even if your lordships are to hold that 233 does not today prevent in-service candidates from being eligible for direct recruitment, the language of 233(2) is very clear, my lords, that the experience of 7 years of advocacy is not applicable for in-service candidates. Any eligibility which now has to be formulated, my lords, can only be prospective. Any such eligibility, my lords, cannot be in a retrospective manner read into 233. These are my submissions. I'm extremely grateful for the opportunity.
Yes, Manoj, I am appearing for the State Bar Council of Madhya Pradesh, Malad. That is IA intervention number 24074.
So I appear for Allahabad High Court, Milords.
So who is Mr. Yashovardhan?
Yes, Mr. If I appear for Allahabad High Court, I adopt the submissions of Mr. Gupta, Milords, squarely. Because that covers below entirely our cases, sir.
Very good, very good.
Okay.
Yeah, proceed.
Very good. Lords, I am for the intervener, my lords, State Bar Council, Madhya Pradesh. This is IA number 2407446 of 2025, my lords. We had helped to trace out the copy. Lords, I have prepared short written submissions also, my lords. May I just pass on, my lord, along with? So that's. My lords, first, my lords asked a query in the morning, my